UTL Radio welcomes you to this episode of Legal Q&A Live. On this program, we answer our listeners' legal and business questions that have been submitted during the week or are asked during the live show. As always, we welcome input and feedback from you, the listener, and we encourage you to join in the conversation by calling the live program at 347-855-8831 or by contacting us via our social media sites. Links to our various sites are listed on our main website, UTLRadio.com. Please note that this broadcast does not constitute legal advice and does not create an attorney-client relationship with any of our listeners. And now, your host, Peter Lamont.
Well, welcome to another episode of Legal Q&A Live. We've got a number of questions to get through today. They range everything from pro se representation, amending a complaint, all the way down to mediation questions. So we have some good questions that were submitted this week that we'll get to. Before I start, I just want to thank today's sponsor. Today's show is sponsored by Audible, the leading provider of audiobooks on the internet. Audible has a massive library of more than 100,000 audio programs, and they're providing our listeners with an exclusive offer. Just head on over to audibletrial.com/UTLRadio, and you can download a free audiobook. Absolutely no strings attached. If you go over to UTLRadio.com and scroll down midway through the page, there's also a link there that will take you to the same place. It's a free book that they're providing to our listeners, so with no strings, no risk, it's well worth getting your free book. You're not obligated to join the Audible program, but you know, how often do you get anything free in today's world? So take advantage of that. Either check on the website or head on over again to audibletrial.com/UTLRadio. All right, just to catch you guys up, yesterday we had our regular scheduled week in review, and we talked a lot about some interesting cases, the Ebola issues that are still ongoing. We talked about an update between what was going on with the Activision case, the Call of Duty case, where Manuel Noriega is suing Activision for use of his likeness. And now we've got former New York City Mayor Rudy Giuliani on the case. So it was a very interesting show yesterday. If you want to download that episode, you can either go to our page on Blog Talk Radio, or you could head over to utlradio.com, and there is an archive section where all of the episodes are there. You can stream them or you can download them. I also want to mention that while we are on the radio today, we're also simultaneously broadcasting live on YouTube Live. So we're going to be able to connect with you guys both on YouTube Live and on the Blog Talk Radio station. So chat rooms are open on both. If you have additional questions or you want to follow up with a question that we addressed today, please feel free to do so via the chat. All right. I also want to mention that another way for you to listen to all of our programs and to have access to our complete video library and the special feature of being able to ask a lawyer a question from your iPhone or iPad, you should download our free app. It's a free app in the iTunes store. It is available for iPhone and for iPad, and it allows you to type in your question, your legal question, and it goes directly to an attorney in our office, and then we respond. And it's free. It's part of our community outreach. It's part of our desire to help you guys get a better handle on some legal issues and understanding the law, which is why we do all of these programs. So download that free app. It gives you a ton of information. Also want to remind you, this Thursday coming up, we've got a very, very exciting interview on Understanding Business, Thursday at 10 a.m. with Captain Lee. He is the star of Bravo's television show Below Deck, and he's going to talk about leadership and management and what you can learn from his style of leadership and management, and how you can put that into play in your own life, whether it's, management at home or management at work. So it's going to be a great show. That's 10 a.m. Eastern time. Again, full programming schedule available at utlradio.com. Final thing before we get to the questions, I just want to remind you guys that, your feedback is critical to me being able to provide you with the best content, the best guests, and the most applicable content to you. But if you don't interact and engage here, you can do so via social media, Twitter, Facebook, Google Plus, or live during the call-in shows or through the chat rooms. We don't know if this is what you want to see or hear. So I encourage everyone who watches this show, whether it's live, downloaded later, however you do it, make sure you contact us and give us your feedback and let us know, hey, this is great. We would like to see more of this. How about questions concerning this area of law or business? Make sure when you go over to the YouTube page, just give us a thumbs up. Let us know that what we're doing is something that you guys like. It's important that we understand that because we're doing this for you. So, instead of me just sitting here talking and giving you information that you might not want, it's better for me to know what sort of information you're interested in, and then I can better, tailor these broadcasts. All right, enough of that. Let's get right into the first legal question. So this question is asked by an individual who has filed a lawsuit, and the question is, if I amend my complaint, am I obligated to point out to the other party exactly where the changes were made or the claims added? So this is a situation where you've got somebody who is a pro se litigant. They're representing themselves. They don't have an attorney, and they filed a complaint. And now they want to know if they can amend the complaint, and do they need to notify the other side what they're changing, what they're amending in the complaint? All right, the simple answer to the question is no, you don't need to notify anybody about what section of the complaint you amended. There's no obligation, at least not in New Jersey. There's not one in New York. And I'm comfortable saying that the majority of states don't have that requirement either. You don't need to point out to the opposing counsel, hey, I modified paragraph 2, and that's why I'm filing this amended complaint. It's enough for you to file the amended complaint. There are attorneys who, as a courtesy to opposing counsel, will either call them up or send them a letter and say, listen, I'm going to amend the complaint, and here's what I'm going to do because this is wrong, or I've introduced a party that shouldn't be a party. And as a courtesy, they do that. And it is helpful if you're the attorney on the other end to have that dialogue with your adversary, and you can kind of work together to do your job. And see, that's something that I think a lot of people, they don't understand. You have those lawyers who are just absolute jerks. There's no other word to describe them. But there are good lawyers out there who are doing the best to advocate on behalf of their client. And simply because you have a different position from that attorney, like you represent the plaintiff and that attorney represents the defendant, you can still get along because as attorneys, you're both doing your job. This attorney's job is to protect the plaintiff. This one is to protect the defendant. That doesn't mean that the lawyers have to hate each other and make this even more adversarial than it already is because the parties are adverse. The lawyers, it's nice to see lawyers be able to work together and to be able to be courteous to one another. Unfortunately, that just does not happen often enough. And you've got lawyers that, will waste time and waste their clients' money simply because they're a jerk. They won't, agree to something that the court's going to grant anyway. A lot of times you'll have an adversary who you need an extension of time for something, and darn well the court's going to give it to you because it's part of the rules, or that's you're right. And you go and you can, talk to the other side and you try to convince them, hey, listen, would you do me a favor? I'll extend you a courtesy. You extend me a courtesy. And then they tell you no. And, now you've got to file a motion and now you're wasting your client's money. It's unfortunate that lawyers have to act in that way, but that's just a tirade and that's not answering your question. Answer to the question is absolutely not. You don't have to tell anybody. Can you? Yes, but you're not obligated to tell anybody about the amended complaint. One thing that I will point out to you, and I'm going to stick with New Jersey for a second because that's where this question is coming out of. But if you're in another state, the same rules are going to apply in the sense that there are rules concerning when you can amend a pleading, a complaint, or an answer. So let's just go through New Jersey. New Jersey's rule 4:5-1 says that you are allowed to amend a pleading, or in this case, a complaint, at any time prior to your adversary interposing an answer or response to pleading. So what does all that mean? If I file the complaint and my adversary hasn't filed their answer yet, I can, as a matter of right, amend that pleading. Okay, I can absolutely just amend that pleading. I don't need to ask anybody's permission. After your adversary enters an appearance, in other words, files an answer, now it's a different story. I don't have that freedom to just amend. Oftentimes you have to file a motion to amend the pleading. And, your adversary gets to see the proposed amendment in that motion. But that's, again, something separate. We can talk about motions to amend the pleading on some of our other shows, maybe on a law basics episode. But the answer to that question is no. You do not need to notify anybody of what the changes were. All right, next question. This person was served papers from court and a lawyer, but claims that they're the wrong person and that the content has nothing to do with me. How do I clear my name? All right, let's read on a little bit because that initial question is a little confusing. I was served with documents which name my name and address as the plaintiff, but I have no idea, nor does the content of the papers pertain to me. I called the lawyer and he was no help. He just said I was served. What do I do? How can I proceed to get my name and address off these legal documents and make sure I'm not messing anything up? All right, well, this is an odd situation because, I could understand if he was saying I'm a defendant in the lawsuit and I didn't know why I'm a defendant or what I've done wrong to be a defendant, because often that happens where you are, in a group and there was a trip and fall accident or something and somebody thinks you might be responsible. So they get your ID and they name you. But this says he's the plaintiff. So there's only a few circumstances where this could happen. Okay, now remember, why would a lawyer file a lawsuit on behalf of a plaintiff who he doesn't know? How is he going to get paid on this case, right? It doesn't make any sense. Here's what I think happened, and I'm going to leave this up to the asker of the question to go back and try to kind of recreate what might have happened here. The one time that I'm aware of incidents like this occurring is in automobile insurance litigation or property insurance claims. So when you are insured by a piece of insurance, whether it's an automobile policy, right? It's your auto policy, your homeowners. In your contract for insurance, you provide your carrier, your insurance carrier, with something called the right of subrogation. So what does that mean? And I'm going to explain it because I think that might be what happened here. So subrogation essentially is one party stepping into the shoes of another party. Okay. Now, in the insurance world, let's stick with a car accident for a second. So in a car accident case, let's say that I'm rear-ended by Mr. Jones, and I go to my insurance company and I say, hey, Progressive, Mr. Jones rear-ended me. It caused damage to my vehicle. Could you fix it? That's what I have insurance for. And Progressive says, sure, you have a $500 deductible. We're going to fix the car. And then they sometimes say to you, we're going to try to get your deductible back just to let you know, but don't hold your breath. And you pay your $500, you get your car fixed, or you get the check from your insurance company, and you are on your way. Well, what you don't know is that if they believe that they can attribute liability to the person that hit you, they'll file a lawsuit in your name. So it would be something like, let's say your name is John Doe. Progressive Insurance as subrogate of John Doe versus Mr. Smith. Okay. They're stepping into your shoes. They're taking, because you have a legal right in that instance to sue the guy that hit you from behind. But you're going to your insurance company saying, insurance company, make me whole. You're not going to sue the guy that hit you. And now the insurance company says, well, you had a legal right to sue the guy. We are going to step into your shoes and we're going to sue on your behalf. And if we recover money, you, the driver, are not entitled to it because we've already paid you. We fixed your car. You are entitled to recovery of your deductible, but that generally doesn't happen because if, let's say, for example, the insurance company paid out $3,000 on your claim and your deductible is $500, they may oftentimes settle with that other party or the other party's insurance company for less than what they paid out. So in order to avoid the expense and hassle of ongoing litigation, what they might do is they might accept a settlement offer in the amount of $2,000. Now they paid out $3,000, your deductible is $5,000, they're going to settle for $2,000. Where does that leave you and your deductible? Nowhere, gone. So I am curious in this case, and again, the asker of this question should go back and think, have you been involved in an automobile accident? Was there damage to your vehicle? Even if your vehicle is parked on the side of the street, is there property damage? Have you had any reason to go to your insurance company and to file a claim? And did you get reimbursed by your insurance company? Because if that's the case, then there's a good chance that this is a subrogation matter, and that's why your name is listed as the plaintiff. But again, that's speculative. You guys, the asker, you've got to go back, you've got to check and see, is any of this true? Now, if it's not true and you've got no insurance claim, and this you don't see on that complaint an insurance company and the letters A/S/O as subrogee of, then I would call an attorney and hire an attorney to see exactly what this is, to make sure that it's not some variation of identity theft or anything. But I would suspect that it's subrogation. You have to check that out for sure. All right, next. This question: served papers from the court and a lawyer. Oh, I'm sorry. This is the same one. Must have printed this one twice. So I'm sure you don't want to hear that long-winded answer yet again. So let's go to the next one. All right. Mediation for child support. I'm wondering if my ex-wife and an attorney must be present during the mediation. I feel it's a conflict. I prefer that she does not have the right. Okay. So what this person is asking is, we're going to mediation for child support, and it's an ex-spouse. So it's him and his ex-wife. And what he wants to know here is, does he have to have a right, or does his wife have a right to take an attorney to the mediation? And he wants to try to prevent that because he feels it's unfair. So let's just see. Give me 1 second. I just want to welcome to the people who have signed in. Welcome to all the guests. Getting back to the question. So does his ex-wife have a right to bring her attorney to a mediation? Well, the answer is yes. I mean, she can bring an attorney, but it often hinges upon whether or not the mediator thinks it's a good idea. Remember, mediation is meant to be a means of working out your differences in a more amicable fashion than arbitration or through a lawsuit. Okay, so the idea in mediation is, let's sit down and try to work out our differences so that we can avoid the hassles and expense of litigation or arbitration. And sometimes by bringing an attorney, it can create sort of an adversarial feeling to the mediation, because now you've got a lawyer, and do I bring a lawyer? So the answer to this question is, does she have a right to bring a lawyer? Yes. Should she bring a lawyer? That's up to the mediator, and that's something that you really have to talk to the mediator about. Talk to your ex-wife about it. If you can't talk to her, talk to the mediator. Say, listen, we've got a mediation scheduled. I want this to be resolved. I know my ex-wife does too. What should we do about bringing attorneys? Now, let me just add this. In the event that the mediator says, listen, I cannot prevent her from bringing an attorney, your best bet is to bring an attorney too. Right? That way you level the playing field. Now, I understand that there's always the expense associated with hiring an attorney, but think about the expense that you're going to suffer if, in fact, your ex-wife does have an advantage over you in the mediation. You're going to, I don't know who's seeking the child support modification, whether it's you or her, but if you don't have an attorney with you and she does, and you feel that you've got an unfair advantage, well, you might, and therefore you could spend more money if a child support award is awarded against you in a higher amount than what you're paying now. So bring an attorney, level the playing field. I know that, again, it's expensive, but figure it out from a business standpoint. Where are you going to spend the more money? Are you going to spend more money on bringing an attorney in and having a better chance of trying to resolve it? Or are you going to save money on the attorney, but then spend more money every month on the new child support modification? So you have to think business minded in order to make some of these decisions, and really try as hard as it is. And believe me, I know this is much easier said than done. Try to act when you're handling legal matters. Try to act without emotion. Okay. Try to act with a business mind, with your focus on a business approach to your case. It's so hard. And that's why I tell most people, listen, if it's not a special civil or small claims or whatever the court is in your state, the lower court, if it's not something that's only a few $100s or $1,000 where you can handle it yourself, and if you lose, it's not the end of the world, then fine, go ahead and do it. But in situations where the stakes are a little higher, don't represent yourself. Go find a lawyer that you connect with and hire him or her to help you, because the old adage, a lawyer that represents themselves has a fool for a client. Well, it's the same thing with pro se litigants. If you don't really understand what you're doing and you throw yourselves to the wolves right out there as a pro se litigant, you are going to be taken advantage of. There's no two ways about it. The courts, while they're lenient, quote unquote lenient, with respect to pro se litigants, they still expect somebody acting as their own attorney to know the rules and know the procedure. And while maybe the judge will bend some of the procedures slightly, they typically do not make exceptions for pro se litigants. So if you've got a situation where you feel that you need to have an attorney, you probably do, right? If you've got bigger stakes, make sure you get somebody to help you. Don't try to save money by not hiring an attorney, because it's going to cost you more money in the long run. So that ties into this mediation question. But answer to the question, can you stop her from bringing an attorney? No, you can't. The mediator might be able to suggest that, but you can't. All right. Next, this person is asking how you go about finding a pro bono lawyer. I have a civil case that's going to a proof hearing, and I need a pro bono lawyer ASAP. Well, let's talk for a second about pro bono lawyers. And let's sort of break down some of the myths about pro bono work. All right. So a lot of times, lawyers will get calls from people who say, I don't have any money. I need to hire an attorney. What are the obligations of providing pro bono support? Will you take my case pro bono? Why won't you? Why are there lawyers out there that will take a case pro bono and you won't? Well, let me explain a few things. First of all, most attorneys do some form of pro bono work. In the state of New Jersey, every attorney is entered into I'm going to say lottery, but it's not like that kind of lottery. They randomly select attorneys who handle pro bono matters throughout the state. So, for example, in the last 3 years, I've handled one pro bono assignment that was mandated by the state of New Jersey. I had to cover that case, even though that case was in criminal law, an area that I don't practice in. They don't care. They pull out randomly an attorney and they say, you're going to do some pro bono work next month, and here's your assignment. Now, that's the mandatory that New Jersey imposes. There are other states that do that as well. But we also take some pro bono cases. Well, why? Well, it depends on the circumstances. It depends on the plaintiff that's calling us or the client that's calling us. Sometimes, there's that human element, that human component to being a lawyer that is often overlooked. And we might feel like, A, it's something that we can do well for this person, and B, it's something that we can afford to do, because that is a critical factor when you say, why won't attorneys take things pro bono? We have jobs, right? And whether you own a firm or you work for a firm as an attorney, it doesn't make a difference. We have to make a living too. And there's going to be hundreds of people out there saying, lawyers are bloodsuckers and this and that. And you know what? I have to agree with you. There are a lot of lawyers that are like that. There are a lot of jerks. There are a lot of people that believe that they are better than you simply because they have a law degree. Well, that's not everybody. We certainly don't feel that way. I sit here every week and I give out free information that doesn't benefit me at all. I do it because I want to give you guys out there a better understanding of your rights and your obligations, because I think that's important. I don't think there's enough emphasis on that. You've got people that are complaining because they're going 40 in a 35 mile an hour speed zone and they get pulled over, And the officer says, yeah, you're going 5 miles over the speed limit. And they said, well, we didn't know there were no signs. Well, I don't like that feeling, right? I don't like that feeling of not knowing what your rights and obligations are. And that's why we're trying to do this. So you can consider what we're doing a form of pro bono work. But you have to understand that we run a business. And so we have to be able to have enough money to pay salaries and to pay overhead. And again, I'm not talking about those greedy, selfish lawyers, but that's not just the law profession, right? It's everywhere. Doctors, lawyers, bankers, you name it, and you've got bad people in any profession. You've got bad pre-K teachers, right? No matter where you go, you're going to find bad people in good professions. But for those people who are always saying, I don't understand why they won't take my case pro bono. Maybe the firm that you're going to can't afford to take your case. Maybe the attorneys have looked at your case and realized that it takes so much manpower to do an effective job on your case that they can't afford to do it. Well, then you say, but what about some of these other firms that all they do is pro bono work? All right, let's explain how these guys work. So there's something in New Jersey out of Essex County called the Volunteer Lawyers for Justice. And they're a really great organization, and it's run by attorneys who are at very large white shoe type law firms. And they help a lot of people, and it's great. But how do they work? They're a nonprofit organization. Okay, now let's explain nonprofit, because you guys have all heard nonprofit organization. What does it mean? How do they get paid? Well, I'm going to tell you how they get paid. Nonprofit means that the organization doesn't make a profit, but what they do make is money from all of the donation sources, and they use that money to pay all of their employees and staff and expenses and overhead. Then what's left over is distributed to the charity. That's why when you watch shows like The Real Housewives and you see somebody sponsoring a charity event and it's lavish and they've got all of this entertainment and food and you name it, and it's just extravagant. And then you find out that they raised $5,000 for the charity, but the party cost them $1 million. Well, wait a minute. How did that work out? You had all these guests there. You spent all that money, and you're telling me you made $5,000 for your charity? Well, that's because they made $1,005,000. $1 million, that money went to pay all the overhead and expenses, paid the band, paid the food, paid the tent, paid the staff. And then that balance, the leftover, the $5,000, that's their charitable donation. So with organizations like American Cancer Association, March of Dimes, they're really good organizations. So don't get me wrong, but everybody that works there gets a salary. Where does the salary come from? From the donations. Okay. The residual, the leftover, is donated to charity. So it's not staffed fully by volunteers. And that's the way that a lot of these pro bono organizations for lawyers in your state work. They're not staffed necessarily by volunteers. They're staffed by people that are making a full-time job out of helping people, but they're still getting paid. And that's, I think, the misconception that people are oftentimes unaware of. So answer to this question is, what you need to do is you need to look in your state, see if there are such pro bono organizations that you can go to, like in New Jersey, Volunteer Lawyers for Justice. Present your case to them and see if you can get somebody to help. You can always call an attorney. Maybe you find somebody on avo.com, or maybe you find somebody just from searching the internet in your area. You can always give them a call and say, listen, here's my matter. Can you help me? I think, unfortunately, the reality is that the vast majority of attorneys that you call will just turn you down flat, because as soon as they hear the word free or pro bono, they're done. But there are attorneys out there. I'll tell you, we listen to people every day. I take every phone call that comes in and either, talk to them when they call in, or we reschedule it so that I have time for them. And I listen to them. And if the case is something that I can't help them with, we try to help refer it to somebody else. If they're looking for someone to take something on a pro bono basis, if it's something that's not going to cut into our ability to either perform properly or our ability to pay overhead and expenses, then we'll consider it. So no harm in giving it a shot, but that's what I would do when it comes to pro bono work. And I hope you understand why I went into this big discussion about pro bono and charity work, because I need people to understand how it works, right? If you look at some of the salaries, if you're ever curious, go and Google some of the salaries for the people that work at some of these charitable organizations. Go Google the salary for the individual that's responsible for the March of Dimes. When you see the salary, you will fall off of your chair. That's not to knock the organization at all. They serve a worthy and worthwhile cause, but just go check that out and then let me know what you think. All right, next question. How to defend myself at a small claims court and change the date of court because I work outside the state. I've been accused of dumping garbage on a non-garbage day in front of my mother's apartment that she rented. The landlord was ticketed and wants me to pay. I don't live there. In fact, I live out of state. I work out of state. I'm not able to make that court date. What can I do? All right, so first, let's break it down. He wants to adjourn the court date. Not a problem. How do you do it? In municipal court, you simply write a letter to the court clerk and ask for the adjournment. Give them a reason why. Explain to them, listen, I'm aware of this matter. I'm either going to be retaining an attorney or handling it myself, but in any event, this date is not convenient for me. I work out of state and I'm unable to attend. Good enough. They will 99% of the time, they'll give you the extension because every court, not just municipal courts, but every court favors litigation or criminal prosecution on the merits, meaning they don't want to just win with you not showing up, because then you might be able to appeal that decision. So people in the legal system, whether it's criminal or civil, would much rather litigate or prosecute a claim with you there. So requesting an adjournment is something that happens all the time. And in municipal courts, it's given out quite freely, as long as you can give a reasonable explanation. Now, moving on to the second part of that question. I'm out of state. What do I do? Okay, well, you've got three options. Option one, you pay the ticket. Okay, you pay the ticket. Simple as that. Option two, you hire a lawyer. Now, if the ticket, and I would imagine that a fine for garbage, such as described in the question, it's got to be less than $400. It's probably somewhere in the area of $150, $200, maybe. Hiring a lawyer is going to be more expensive than resolving the claim or the ticket, right? I mean, unless you get some lawyer that is willing to take cases at $100 an hour, maybe somebody right out of law school or somebody that doesn't have a client base, maybe, right? Maybe you can get them for $100 an hour, but it's going to be really tough. And you're going to end up probably spending more money than what it would have cost you to settle the ticket. The third thing that you can do is take time off from work and go in and appear on the court date and state your case in front of the judge. So if you want to look at this from a business standpoint, what makes the more or the most economical sense for you? Does hiring an attorney, and assume for a minute, again, we're going to be speculative here, but assume for a minute that the complaint is $150. That's what the ticket is. They want $150 for your improper garbage dumping. Whether you did it or not, let's just look at the business elements here. So A, you give them $150 and you're done, right? B, you hire an attorney, and let's say you get an attorney for $100 an hour. Believe me, it's going to be 4 to 6 hours worth of time that you're going to be paying them. So you're paying $600 for a $150 fine. Even if you win, you lose, right? Now, third option is you take time off from work and you come on in and you argue and you show the judge you didn't do it and you win. But what did you lose? Did you lose a day off? Did you lose a day's worth of pay? How much did it cost you to commute from wherever you are to the municipal court, right? Excuse me. So that's the business element of this. what makes more economical sense for me? And that's up to you. If you are vehement and adamant that I did not do this is not my responsibility, and come hell or high water, I'm not going to pay this fine, fine. But be aware of what it's going to cost you to go and defend this. So, there are times where maybe you just suck it up, even though you know that it's not true. You pay that fine because it's going to save you hundreds of dollars in the long run. All right. Next question. My car got rear-ended while standing in a traffic jam. Should I be calling the insurance company of the party at fault? All right. So it looks like her car was totaled. It's going to be $15,000 to fix. She wants to know, should I be calling the insurance company of the party who is at fault, or will my own insurance company, Progressive, and there was no connection between that example I gave before, will be calling them directly? I'm hoping to get more than the Blue Book value of my car, incorporating the fact that my car was in perfect shape and now I don't have a car. Any advice on the next step? Police report is expected in another 2 to 3 days. Not aware of insurance company. All right, so there's a lot of issues here, a lot of questions that we can get to. First of all, police reports always list the insurance codes for both yourself and the driver. There's typically a 3-digit code, and it'll say something like INS period or code or whatever. Police reports always have a key, by the way, a second page. It's a key that you can line up with the first page, and it'll tell you with little arrows what each of those boxes are. Keys are available for download on most state websites. Most local websites, will have them as well. So you go to your state police department and you ask for the key, and now you can see what all those boxes are. The insurance codes can be looked up quite easily. You go to your Department of Motor Vehicles on the website, you type in insurance codes, you look at the code, and then you know what insurance company it is that you're up against. But your question is, and the primary question is, should you be calling the insurance company for the party at fault? Well, sometimes you might, but not here. Here's what you want to do. You need to make sure that Progressive knows about the accident. You need to fill out a claim form. You need to have Progressive open a claim. What'll happen is you can do it online. Honestly, you can submit your claim online, and they'll assign a claim number and a claims person to represent you. They'll then contact you and ask you for details about the accident. They may want to inspect the vehicle, so they might send somebody out to come and inspect the vehicle. They may want you to give them a statement, and then they will pay you for the car. Now, you want more than the Blue Book value. Generally speaking, not going to happen. Okay, depends on your policy, depends on your carrier. Not going to happen. They're going to give you the estimated value of the car. They're going to try to make you whole, but they're not going to give you more than the car is worth. Okay, maybe they can give you, the damages, what it costs to repair it, and if it's total, they'll give you, maybe replacement value. But that's something you have to deal with your insurance company over. If you think that this is kind of like a golden ticket, I have a $15,000 car, but it's in pristine condition, and when I bought it, it was $30,000, right? So $15,000 in damages. I bought it at 30, pristine condition. I want more than 15. Not going to happen. But your insurance company will resolve that claim for you. Now, remember earlier in this segment, we talked about subrogation. Well, here's an incident where your insurance company, Progressive, will go after the driver that rear-ended you. And they will try to recoup the money that they paid out to you, and they'll try to capture your deductible, which, as I explained earlier, doesn't happen all that often. But that's how this works. Do you need to call the other side? No. If you're injured, okay, if you have personal injuries, then you need to call a lawyer immediately, because there are things that you need to be doing. Medical treatment, having a doctor, analyze your potential injuries, that sort of thing. So injuries, you immediately need to contact a personal injury lawyer to make sure that your rights are protected, in addition to making sure that you're seeking proper and appropriate medical treatment, right? Oftentimes, you get into a car accident, you sustain an injury. And it's not until 3, 4, 5 days later that you start to feel the effects. How often, for those of you who have been in an accident, how often do you have this, build up adrenaline because you were just in a car accident or a slip and fall, and you don't feel the pain yet. You're embarrassed. You want to just get out of there and go home, and then you go home, and later on that night you start to feel a little sore and pain. And the next morning you wake up, and now you're in even more pain, and you still don't do anything. And the third day you're in so much pain that you have to go to the doctor. And now you say to the doctor, well, 3 days ago I was in a car accident, or 3 days ago I slipped and fell. That's how injuries work. Okay, so if you don't have something like a break or a fracture that happens at the time of the accident, soft tissue, neck and back, spinal injuries, nerve injuries, those might take a day or so to fully develop. So make sure you're seeking the appropriate medical treatment. And then if you have these personal injuries, you need to go to a personal injury attorney. For the property damage claim, right, there's two separate things: personal injury, property damage. For the property damage claim, you don't really need to do anything except alert your insurance company and stay on them. Communicate with the claims person. Ask them what's going on. When can you expect to be paid? Do they need to inspect the vehicle? When is the inspection going to happen? Can you be present at the inspection? So on and so on. Get the information that you need. You pay your insurance company every month in a premium, right? Shouldn't you know what's going on? Absolutely. So I hope that answers your question there. All right. We have about 19 minutes left. So let's do one more question, and then, just some notices, and then we will wrap it up for today. Final question. Would it be a waste of time to file a motion to compel the plaintiff to answer interrogatories? All right. So it looks like it's kind of confusing the way this is written. It looks like what has happened here is this gentleman is representing himself in a breach of contract claim, and he has served interrogatories on the other side, and they have not yet answered them. Okay, so let's go and look at things one at a time. What is an interrogatory? An interrogatory is a question that you serve on the other side in litigation, which they are obligated by your court rules to answer, okay, assuming that the question is appropriate. Now, we could do a whole show about interrogatories and discovery, but for the fact that we have, only a short amount of time left, let me just explain that discovery demands. It's a tool that lawyers and litigants use to gain factual information from the other side. I want to know what your defense is. I want to know what documents you're going to rely on at the time of trial. I want to know what your theory of liability is. I want to know what your position is. I want to know all these things that are going to help me build my case in preparation for trial. That is this period called discovery. So you engage in the period of discovery by exchanging documents. And you do that by serving discovery demands. One demand that you would use is something called an interrogatory. And this, again, is a question that you ask to the adversary, and you want them to answer it. So each state has their own procedural rules concerning interrogatory demands and answers. And you need to look up your state's rules concerning interrogatories. Some states limit the amount of questions you can ask. Other states require you to use form interrogatories for certain types of accidents. So you need to familiarize yourself with the court rules enough so that you know what your limitations or abilities are with respect to serving an interrogatory. Now, in this case, the asker of the question has already served interrogatories on the other side. And depending upon your state, you may have 60 days to answer them, 45 days to answer them, 30 days to answer them. That depends on your specific state. That gives you, you look at your rules of procedure, and it'll tell you how long you have to respond to interrogatories. So, assuming here that the asker of the question is correct, that the time for the opposing counsel or adversary to respond to the interrogatories has passed, what can they do? how can they go and enforce their right to obtain answers to their interrogatories? Okay, so again, this is very procedural in nature, and you're going to have to check with your individual state, but this is the general process. Most states require a showing of good faith that you tried to resolve this issue on your own without involving the court. What does that mean? You send a letter to your adversary. Dear Attorney Smith, on August 1st, 2014, I served upon you interrogatory demands. You had 60 days to answer them. It is now October, 21st or 20th, and your time to answer those demands has passed. Please be advised that if you don't provide answers within the next, and you pick a time, 2 days, 3 days, 5 days, we will be filing a motion to compel, and I'll get into some of the other motions in a second, but we'll be filing a motion to compel. Send the letter, and oftentimes you're going to get a call or a response, or you'll get the demands. Now, if they don't respond to your good faith letter, your good faith attempt to get the interrogatory answers, then you have only the choice of filing a motion. And again, this is procedural. Check your own individual state rules. But in New Jersey, we would serve a motion to compel. And that would be an order that we would be requesting from the court, compelling them or forcing them to provide those answers. So now there's a court order in place that says you must provide answers to interrogatories within X date. Okay. The other types of motions that are out there, you could file a motion to suppress the defendant's answer. Again, procedural, so check your own court rules. But instead of filing the motion to compel, I could file a motion to suppress their answer for failure to comply with discovery. And those rules concerning discovery and failure to comply are listed in your courts or your state's rules of procedure. So look them up. They're available for almost every state now on the internet. You just need to search up your court rules and then type in the term that you're looking for. Oftentimes there's a clickable table of contents as well. So before you engage in any sort of motion practice, go check your rules. But generally speaking, and answer this gentleman's question, you would want to serve a good faith notice first. Again, telling them when you serve the demands, what time they had to answer them, and the fact that they have not answered them. Then give them an ultimatum, right? Because ultimately you want the responses. And then if they don't give them to you, you file the motion. Now, one last thing I want to point out is that there are times when someone will give you answers to interrogatories and they just are crap. They're the worst answers ever. They're not even fully responsive. They don't answer your question. It's some sort of legal mumbo jumbo that makes no sense, and it just avoids the actual question. That's not okay. That's not permissible. So you have an obligation, or you have not an obligation, you have the ability to go to the court and to say to the court, look, these are the answers you gave me. They're not sufficient. You need to enforce or compel him to provide more specific answers to interrogatories. So yet again, another motion, and you would want to do that typically by first sending the letter to your adversary saying, I served you with interrogatories, you gave me answers. Your answers are non-responsive. And here are the specific issues that I have with your answers. And then you serve that on them. They either, fix their answers or they don't. If they fix them and they're satisfactory, you're good to go. If they don't fix them, then you need to file a motion to compel more specific answers. So that's how the whole thing works. It can be complicated. Again, I just want to impress upon you that if you have a case that is a very small dollar amount and hiring an attorney would be detrimental, you would not make money, you would not, receive quote unquote justice, you'd be paying more to the lawyer, then do it yourself. But if the stakes are higher, go and get a lawyer, because the procedural elements of a lawsuit are so complex that you could miss something minor and end up getting nothing in your case. So, look, you wouldn't go and treat yourself if you had some sort of hernia or a burst ruptured appendix, would you? No. You treat yourself if you have a cold, right? You'd go to your local pharmacy and you'd pick up some over-the-counter cold medication that you can handle, right? And people are honest. I've got the sniffles. I've got a cold. I've got a cough. Let me go to CVS and pick up some medication. But when that medication doesn't help them, what do? They go to the doctor. Why? Because it's now above their pay grade. They cannot help themselves with over-the-counter medication. It's the same in the law. I know nobody likes to hire lawyers. I know people hate lawyers in general. And I can understand that. But there are times when you have to be smart because a lawyer is trained, right? That's what we do, right? If we're a litigation attorney, if we are a trial attorney, and you know the procedure, you're going to have far more knowledge than a pro se litigant would. And you don't want to be the pro se litigant that gets taken advantage of by an attorney because they know the rules and you don't. So know when the matter that you have in front of you is more than a simple cough. Know when it can't be treated by over-the-counter remedies. Know when you need to seek a professional. And there is no harm in calling an attorney and saying, look, I'm not sure if I need to hire you. I'm not sure if I need to hire an attorney. Can you give me some guidance? And while some people might turn you away, there are a lot of people out there that will listen. So that's going to do it for today. I'd like to thank everyone who submitted their question. If you have any additional questions about my answers, feel free to email me. You can email me at info at utlradio.com. You can also head on over to utlradio.com and find links to everything. Google+, Facebook, Twitter, YouTube. Post your comment there. There's also links to our email, and there's a link to our main homepage for the law firm. You could email me directly if you chose at peterlamont@peterlamontesq.com, and I'll answer you. If you have any questions, if there's anybody out there that's listening live or that's going to download this later and you've got legal questions that you want answers to, there's so many ways that you can communicate them to us. And do it through direct email or social media. Download the free app and ask your question there. And if it's a question that you want answered on air, we'll be happy to accommodate you. Otherwise, you're going to get a question back within a 24-hour period. So head on over and find ways to communicate with us. They're all out there for you. Take advantage of the fact that we are here giving away information, trying to help you get a better handle on the law and your legal rights. It's rare that you're going to find something out there that's going to give away free information. So take advantage of it. That's what we're trying to do here with all of our radio programs and our live YouTube broadcasts. All right. The final thing I want to say is, in addition to asking your questions, please, again, leave your comments, leave your feedback. Let us know that this is something that you are enjoying, that this is something that's beneficial, that's helping you. If you've got suggestions on things that you'd like to see, go ahead and let us know. And then that way we can prepare better content for you. All right. Final notice of the day. Tune in this Thursday, 10 a.m. Eastern time. We're going to have special guest Captain Lee Rosebach. He is the star of Bravo's show, not Top Chef. I'm thinking of last week's show, Below Deck. And he's the captain of these gigantic mega $1 million yachts. And he's in charge of the boat. He's in charge of the crew. And we're going to talk to him about leadership and management on Thursday. And we're, really looking forward to it. I think that, it's going to be a great interview. Captain Lee seems like a really, really great down-to-earth guy. So that's this Thursday, 10 a.m. Eastern time, for the player to be able to download it, listen to it. Head on over to utlradio.com. All of the information is there, including a link to the player. You can also select our show through iTunes and download it, subscribe to it, and then every time there's a new episode, you'll get it. Also, just check out last week's interview with Fabio Viviani. Fabio Viviani is from Top Chef. He's also a restaurateur. He is now the owner of a line of cookware that's being sold at Bed Bath & Beyond. He's an author. He's in so many different businesses, but his I think, most notable role for most people is on Bravo's Top Chef. And last Friday, we had an interview with him. It was supposed to be Thursday, but there was some scheduling conflicts with his marketing people, and it ended up being on Friday. But it's a 30-minute show, a 30-minute interview, and he really is down to earth and straightforward and talks about his business experiences and how he views himself as a tank in business and what lessons you can learn from him. So head on over and visit the sites, download the app so you can listen to last week's show. Make sure you tune in live this Thursday, 10 a.m., or download the show later to listen to my interview with Captain Lee Rosebach from Bravo's Below Deck. If you have questions and you'd like to submit them for Captain Lee, do so via our social media pages, do so via email, and we'll ask them online, or ask them live, I should say. And if you are interested in listening live and calling in and asking Captain Lee questions, the call-in number is 347-855-8831. That switchboard is always open during the live programs, and you can call in and ask your questions. Tonight, in fact, is the season finale of Below Deck on Bravo. So for those of you who are Below Deck fans, you'll be able to see the finale. And if you have questions, write them down, get them into us so that we can talk to Captain Lee about leadership management and have some time to ask him some questions that you might have about the show or about him being captain of the boat. So I'd like to thank you for joining me today. Thank you for submitting the questions, for continuing to provide feedback. Over on YouTube, if you guys wouldn't mind, click down below, give us a thumbs up, let us know that you like the program. And thank you for tuning in this Thursday to talk to Captain Lee. If you have any questions about anything that we've done or said, please feel free to contact us and we will get back to you. In the meantime, join me Thursday for Captain Lee's interview. And remember that there's power in understanding the law.